Thank you for joining Mayer Brown's Investment Management webinar. Our program today will focus on Robo-Advisers and Advisors Act compliance. My name is Amy Pershkow, and I'm delighted to participate with my partner Stephanie Monaco on today's topic. I'm a corporate and securities partner in Mayer Brown's DC office, focusing primarily on representing investment companies, investment advisors, and other financial services companies. I'm pleased to introduce my fellow presenter, Stephanie Monaco, who is also a corporate and securities partner in Mayer Brown's Washington, D.C. office. She advises investment management firms, investment companies, and hedge funds across a broad range of investment management needs. She's formerly attorney with the U.S. Securities and Exchange Commission and brings a deep understanding of the regulatory environment to counseling clients on issues of compliance and product development. With that brief introduction, let's get started. So Robo-Advisers. We're going to start with an overview of what they are and their programs. So a robo-advisor is one that uses algorithmic and other technology-based programs to provide clients with discretionary asset management services, typically with limited human interaction through online electronic-based models, delivery models. Robo-advisors offer varying levels of human interaction. Some provide limited or no human interaction between the client and investment advisory personnel. Others provide advice through investment advisory personnel using interactive platforms and models to generate investment recommendations that are then discussed with the client. Others make humans available to clients who utilize their online advisory platforms. So at the Division of Investment Management and the staff of the Office of Compliance, Inspections, and Examinations of the SEC have been monitoring robo-advisors and evaluating how they meet their obligations under the Advisors Act. At the end of February, the investment management staff issued a guidance update that focused on robo-advisors that provide services directly to clients over the Internet. The update describes what the staff says are unique considerations that robo-advisors should keep in mind as they seek to meet their Advisors Act obligations, and specifically their disclosure, suitability, and compliance obligations. In addition, OC listed electronic investment advice as a new focus area for its 2017 examination priorities. The update that's published at the end of February focused on the three specific areas I just mentioned: the substance and presentation of disclosures to clients about the advisor and its services, its obligation to obtain information from clients to support its duty to provide suitable and individualized advice, and the adoption and implementation of effective compliance programs that are reasonably designed to address particular concerns when providing automated advice. So we'll start with disclosure. Just like all registered investment advisors, robo-advisors have to provide full and fair disclosure of all material facts, including conflicts of interest, concerning the services they provide to their clients so that the clients can make informed decisions about whether to enter into or continue an investment advisory relationship with the advisor. Because robo-advisors provide advice through electronic means, websites, mobile applications, email, rather than through an actual person, the staff believes that there are unique issues that those advisors face with respect to disclosures that they provide to their clients.
Now, I would just interrupt at this point, and I make note of the fact that it seems like since this guidance statement came out, we're reading more articles from places like Ignites, for example, in describing robo-advisor programs that third parties are bringing out to the market. I've noticed a greater emphasis being placed on human interaction and human involvement, as well as focus in these articles on allowing the investors who are availing themselves of these programs to find some way to impose their own unique restrictions on the investments that will be made in their account. So it would seem that these publications that pick up on stories concerning robo-advisors, anything really in the advisors industry, are bringing to attention programs that, again, are starting to customize more. For example, the other day I saw a robo-advisor platform described in an article, and it pointed out that investors can suppress or say no to upwards of 3 different funds that typically are included in a model portfolio that they can choose from. Other circumstances as recently as yesterday of another robo program where there is more human interaction and an ability to communicate actually with an investment advisor rep or somebody who can provide direct communication with clients.
Yeah, I think that people may be reacting to what the staff has said in its guidance. I think also as we read in the press and including yesterday's article from Ignite that you were talking about, I think that advisors are doing studies and surveys to see what is it that various targeted potential client groups want. Do they want some level of human interaction? Do they not? You know, I think are they willing to pay for it? Are they not? What are they valuing? And so I think that advisors are seeking out that information and trying to figure out what they think is the best product to put forward.
Which is a very business-friendly expectation and description of why things might be getting a little bit more individualized, a more cynical reaction to that, which I own, is that since this guidance update came out, the staff was able to remind the industry that there is the possibility of creating an inadvertent investment company if every single account is following, let's say, one of 3 models and there is no individualized customization that investors can take advantage of. And that was very pronounced in the guidance statement, and I know we're going to talk about that, or so-called the MiniAccount or Rule 3A4 requirements of a safe harbor a little later on. But the more cynical side, that of me, would say that the reason there is more individualized treatment that is made available to investors on these programs is in response to the staff's reminder that, you know, they still exist and they can come in and look at your program, and if it's not attentive to all the requirements in the guidance update, including that, well, you know, there could be problems down the road.
Right. So let's start with disclosure, which was one of the first areas that the staff identified as a focus area for robo-advisors in the update. They suggested some areas that robo-advisors should consider when designing their disclosures. I think most importantly, we might say that you need to have a very clear explanation of the business model and its related risks. So describe that an algorithm is being used, how is it used, what are its limitations, its risks, whether the advisor has the ability to override the algorithm. So very plainly, you need to say an algorithm is being used. What is that algorithm? How does it work? What is it doing? Is it recommending the client's portfolios? Yes. Will it also invest and rebalance the client's accounts? Most likely, that's what the algorithm is being used for.
Right, but also in connection with that kind of disclosure, it's important to evaluate and sometimes push back on the people who are designing the delivery of your product, push back on the enthusiasm that they typically have. So, for example, you might want to be sure that in addition to talking about what your algorithm is anticipated to do and how you designed it and what the outcome is likely to be, to give some thought to describing what it doesn't do. It's not a guarantee. It is not a foolproof form of investment. It is not, while it is made up of mathematical factors and those are reflective of your philosophy of historic patterns in the market that, once repeated, should have the same outcome. This is not a guarantee. It is important, I think, to make clear that an algorithm fundamentally is a collection of, again, mathematical concepts that, if followed, should produce an expected result. But it's not foolproof, and mistakes and errors can occur in any mathematical formula. So you don't ever want to suggest that following this model has 100% certainty that it will have a result. For those lawyers on the phone, people in compliance, there are some message cases out there when using algorithms and how they are marketed and how they are described. A case from, I think it was 2012, finally resolved, was the Axel Rosenberg case. It is the main one of its kind, but that case provides many lessons to compliance people and lawyers who are advising others on the use of algorithms. I think we're going to get into a little bit more about the compliance aspect of this, but sticking with disclosure for now.
Yep. One of the other things that the staff suggested that robo-advisors consider disclosing is, if you have any human interaction, are there any circumstances when the robo-advisor might override the algorithm to manage client accounts? Is there any circumstance where you might halt trading for any reason? Are you able to take a temporary defensive measure in stress market conditions? Those are some things that the staff considered that you make sure you include in your disclosure if you are able to do that. Robo-advisors should take care also to describe any third parties who are involved in the development, management, or ownership of the algorithm, and any related or actual or potential conflicts that are of interest that exist. So, for example, if you have a third party that is involved with the algorithm, are there products, options that the algorithm may direct client assets into? And we'll talk about fees in a minute, the next bullet point there on the screen, but if there are that third party's products in there, that should certainly be disclosed and brought to clients' attention. You need to explain the fees charged directly by the robo-advisor and any other costs or expenses the client might bear directly or indirectly. So you've got advisory fees, custody fees, fees and expenses that the client would bear indirectly through the funds that are utilized in the program, brokerage or other transaction costs, things that might not necessarily come to the attention of the client as it's deciding whether or not to sign on to the investment advisory program.
And of course, that's very, very important to make sure you get in the disclosure, because the range that I've seen of the advisory fee associated with opening up a robo-advisor account is very low. It is, there's some that are zero, and there's some that I think the most typical range is 20 to 50 basis points, 50 really being the higher end of it. And that is, after all, the big attraction of these programs. The appeal, at least it's believed that this is appealing to Gen Y and the millennials who perhaps don't have much confidence in active management and don't want to spend a lot of money, if anything, on the management of their assets, and therefore are attracted to these products. So if this disclosure point is, you can't convey the notion that the 20 or 25 or 30 basis points that the client is paying to open a robo-advisor account is all in. It's not.
Right. Right. Certainly, as we talked a little bit before about need to explain the degree of human involvement. Is there any at the client level, or is the human involvement solely with respect to oversight of the algorithm? And so those are some disclosures that should be clearly made. To the extent that the robo-advisor has access to client information other than what the client provides through a questionnaire, and we'll talk about questionnaires in a second, does the advisor have access to bank account information, either directly from its own entity or through affiliates? Does it allow clients to provide linking to that information? And if it does have access, does it in fact consider that information? Make sure that, you know, if you have an affiliate that maybe is in the mortgage business, your potential clients could have a mortgage with your affiliate, and maybe those clients expect that you might know how big their mortgage is and understand the information that that affiliate has. And so making sure that you provide disclosure about what you consider and what you do not consider is very important. And lastly, it's important to explain how and when a client should update the information that they've provided to you.
I think also in the disclosure area, and whether this is through the electronic contracts that somebody signs up, I don't know that we're going to talk about the contracts in particular, but again, errors are almost inevitable in any algorithmic approach to investing, almost inevitable. And while we're going to talk in a little bit about good compliance tips on how to either identify and correct very quickly or stay on top of errors that might occur, I think that on a cost-benefit analysis, the way I understand advisors think about pricing these products is for 20 basis points, you're not going to easily want to absorb unlimited liability in the event that there's an error in your algorithm, and it goes undetected for a period of time. So I throw out there the relative advantages and disadvantages of reducing your liability by contract in exculpation provisions and indemnifications, reminding everyone on the call that, of course, in a very retail market, which this is, the SEC staff is not very enthusiastic about an advisor's attempt to reduce its liability in the event of errors. However, it should be evaluated the degree to which that kind of provision should be put into a contract for this kind of service at those low prices.
Absolutely. The other area that the staff under disclosure, under the disclosure heading, the second area of focus identified by the staff is to clearly describe the scope of the advisory services that are being offered through the program. Is it a comprehensive financial plan? It may not be, and I think in most cases it's not. Are you also providing tax advice with this robo-advisory program?
Hopefully everybody says absolutely not.
And the staff warns robo-advisors to be careful not to mislead clients by implying that they're doing some of these things as part of the services that they provide, either by being silent or because of who they are or who they're affiliated with, because there is a limited amount or a complete lack of human interaction for these questions to be asked. You need to make sure that there isn't the implication that these services are included with the program that they're signing up for. Lastly, under disclosure, the presentation of disclosures, the limited human interaction between investment advisory personnel and clients presents unique issues when communicating key information. Are the disclosures effective when someone's looking at a screen and reading through them prior to the sign-up process? Is it effective enough that the client can make an informed investment decision? We've all been at the computer when pop-ups come up, and we just click, 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 click because we want to keep moving. And so are they effective? Are you emphasizing key disclosures with, someone clicks through a pop-up box, just a reminder in case you missed it, really calling attention through pop-up boxes, interactive text, access to additional information. Do you have frequently asked questions? Do you have particular topics that someone might be reading over where if you hover with the cursor, the mouse cursor, additional information might pop up to add context for the clients? And lastly, if you allow your platform to be accessed through mobile devices, are the disclosures formatted properly so that when they're read on a device, they're able to be read the same way as if you were looking at a screen? So the second area identified by the staff, sort of the second larger area identified by the staff in the update was suitability. And all investment advisors, as part of their fiduciary duties to act in the best interest of their clients, must make a reasonable determination that the investment advice provided is suitable given the client's financial situation and investment objectives. So in a traditional advisory relationship, the investment advisor has personnel that interact with clients to form a basis for the investment advice that's given, but robo-advisors rely on other techniques to get client information in order to make their suitability determinations. So client questionnaires tend to be the primary method in an online format that robo-advisors gather information from clients. If there's no interaction involved in the program, there's no opportunity to explain the context for the questions asked, to ask follow-up questions about a client's responses, to provide assistance to clients completing the questionnaire, or to address inconsistencies in client responses. So the staff suggests that robo-advisors consider certain factors when evaluating whether the questionnaire is designed to elicit sufficient information to support advisors' suitability obligations. Do you have enough information from clients to be the inputs for the algorithm so that the algorithm works most efficiently and effectively? Are the questions that you're asking clear? Do you have additional mechanisms through pop-up boxes or other technological methods for providing clarification or examples about what you're asking? And lastly, how are you addressing inconsistent responses? You can use design features to alert a client when one response appears to be inconsistent with a prior response, or you might consider whether inconsistent responses that, even if called to the attention of the client and not changed, that it could be flagged for follow-up by the robo-advisor. Steph, we've been talking a lot about challenges with the questionnaire. How much should you ask?
Well, so let's take a working example here. Let's say that the client gets to the questionnaire and you are very careful in saying up to that point that you should answer the questions in the questionnaire as it relates to the assets you would be putting into the account, but that the outcome, the output of the algorithm once applied to your account will not apply to other assets that aren't going into the account. Let's say you've been very careful about that. And let's say you go and you answer these questions and the answers to the question put you in risk category 7, which is, okay, we'll say it's 75% equity, 25% fixed income, long track record to long time horizon for investing, but you're willing to take on a lot of risk. And let's say that you have gone through this and you say, okay, fine, I score out to risk category 7. But again, this questionnaire doesn't relate and doesn't grab information on these other assets I have in another account, and they're pretty tame. And in fact, the rest of my assets are shoved in my mattress, and this really represents the aggressive part of anything that I hope to achieve by the time I retire in another 50 years. So you have the capability to up the ante on yourself and select, instead of model number 7 that matches up to your risk score, model 10. That that unnerves regulatory lawyers and compliance people, because that is something that unless the client recognizes and signs off and you have documentation that the client gets it, I understand that according to these questions, I should be 75-25 in this particular model, and by shifting it over to 10, I'm 90% in illiquid private equity alternative investments, and the other 10% is in high-yield debt. So you've got to build something into that process that captures the client's acknowledgement. I understand I am selecting a model that represents much greater risk than what my score would be in this questionnaire, and I accept that greater risk.
Right, so a robo-advisor might consider, when they change their score to the riskier option, a pop-up that says, hold on, just want to let you know, this is riskier, we think the others are more appropriate given the information you've given us, you know, do you understand? Yes. And they also might consider having a mechanism in their questionnaire where clients could provide additional information to support the choice that they're making.
Yeah, the problem with the additional information is the more information you get, the more information you're responsible for. So you don't want to expand your risk and vulnerability to knowledge of other assets that are not being put into the program too much unless you're all in. The other point we're saying is, in my experiences, you want to get documentation where a client goes from one risk category to a higher one. It's not as important, in my opinion, it's not as important when the client voluntarily goes to a lower risk category. You don't have as much to worry about. Although a pure academic might say, well, you know, if you have vulnerability and risk, if a client loses money by being in riskier assets, by all rights, you have the same vulnerability and risk if a client has lost investment opportunities or growth potential by being in too low. And probably somewhere in between is the best practice, which is if you have a way of figuring out a client acknowledgement going in either direction, that's probably best.
And so you would expect or recommend that the flag or alert that comes up when a client goes to more risky or riskier option, the disclosure there should be pretty strongly worded, and you should be capturing some acknowledgement from the client that they've read and understand that.
Exactly.
So let's move on to talk about compliance policies and procedures. So all investment advisors have to have a compliance program pursuant to Rule 20647, and they are required to be designed to address the services and products that an advisor offers and provides. So when you have those policies and procedures for a robo program, the staff urged robo-advisors to make sure that not only should they have the policies and procedures that are relevant to traditional advisors, but also consider adopting policies and procedures to address the following areas. Algorithm management. Okay, so on that one,
it applies where you are the producer of your algorithm, and it also applies if you are acquiring a third-party algorithm. I would say generally, and here is part of the difficulty, most advisors, compliance people are not algorithmically compatible. If you put them in a room with the people who are really coming up with these complicated mathematical formulas, they actually really will not effectively be able to speak with each other unless, of course, you have the unique compliance person who is willing and able to wrap their head around complicated mathematical principles. So the first question is, how much is your compliance office prepared to learn this? Prepared to understand what the process is and how to build a model management process around the very important, this is the algorithm after all, is the center of these programs. If there are problems in the algorithm, you've got a big problem program-wise. So first decision is, can our compliance people understand what the model, what you do with models? First, you make a model inventory. You have to pull together every model that you have. You have to validate those models before you allow them to go live with customer assets. That involves a lot of testing, a lot of back testing to make sure that the whole mathematical formula is really coming together and producing what you think and expect it to do. You have to have a process for systematically reevaluating those algorithms to make sure as time goes on they really are doing what you have marketed they will do, that errors have not crept in, that these models with your the people that are actually developing the models, that they don't move on to new generations of the model without properly retiring the old, that errors that do creep in are captured, and to the extent those errors are large, properly escalated up the firm. And again, these are steps that need to be designed, need to be put into place, and need to be monitored and followed. The real key initial decision is, does your compliance office that handles the 20647 responsibilities for a registered advisor, are they capable of doing this? If not, do you need to go out and retain an algorithm compliance specialist, somebody who really could dive in, drill down, and identify problems, issues, errors, changes in these models, overrides to the models, all the necessary things that a registered advisor offering management in this strategy and style really is expected to keep.
And when there are, so algorithms don't always stay the same throughout the life of a program, and maybe the portfolio managers or the algorithm creators want to make changes to the algorithm. The compliance policies and procedures need to have some sort of a process for making changes and evaluating the changes and testing the changes and evaluating what are the potential impacts to client accounts.
And also linking arms with compliance that's responsible for recommending and drafting frequently disclosures. When do you have to tell clients?
Right.
When do you have to tell clients that there's been an error? We cannot cover in this webinar how to go about fixing errors of a broad variety, and maybe that might be a good webinar to have one day, how do fiduciaries fix errors. But you know, typically in an error correction situation, such as was the case when what the damages theoretically are to the clients who have been following the algorithm. The goal in all circumstances is to put that client in a but for the error, this is the place I would have been in place. But when you are using, as is typical in the robo-advisor platforms, mutual funds, ETFs, you can't always clearly and crisply and hit on the nose a but-for world, but for the error, this is what I would have done. You may or may not have bought more or less of a single ETF. What if you have 10 ETFs and 10 mutual fund shares in a standard portfolio, and since the error occurred, new ones have replaced those that were in there? Do you use the new? Anyway, as I said, error correction might be the subject of a future webinar and we would cover this there. But bottom line is, you need to marry the mathematical algorithmic process and programming skills to compliance with and expectations of compliance in the Advisors Act, and that is a challenge.
Right. So other compliance policies and procedures that the staff identified in the update that they believe robo-advisors should consider having a policy and procedure that deals with the client questionnaire, since there's so much reliance on that questionnaire for the program, whether it's collecting information sufficient to support suitability determinations. How is the questionnaire used interactively in the program? Another area is oversight of third parties that are involved in the development or that own or otherwise manage the algorithm or software that's used in the platform. So policies and procedures that focus on client questionnaires, procedures that focus on the oversight of any third parties that develop, own, or manage the algorithm or software. And this could be difficult if they are the algorithm provider. What kind of due diligence do you do? What regular oversight do you do with respect to those parties and how they are managing the algorithm? And then lastly, the staff noted policies and procedures regarding data privacy and cybersecurity, particularly in light of the fact every advisor would be expected to have these types of policies and procedures, but because the program is based in an electronic format, the emphasis on these policies and procedures and the protection of client accounts and information and key advisory systems is highlighted in this area. So the last thing that I think we wanted to do, staff, is just talk about some of the takeaways here. I think the first one that we really just most recently talked about, have the limitations in the algorithm been adequately disclosed? We talked about disclosing how the algorithm works, what it does do, what it doesn't do, and if you're not appropriately disclosing those things, we view that as a key regulatory risk.
Right, and then building the model management process, a good one around it. Somebody asked, isn't robo-advisors and quant shops basically one and the same? And I would say, yes, they are. I think anytime you are delivering an advisory service that is all quantitatively driven, mathematically and algorithmically driven, and that's how you market it, and that's what you say you're going to do, they are exactly the same. I think of quants really as being more on the institutional side, and so maybe robo-advisors is quants meet retail.
Quants meet retail, but primarily through an electronic format.
Right, which gets us into really the stress associated with very, very minimal individualized treatment. So in that respect, many years it's been around, an issue has been around that was somewhat resolved by the adoption of a safe harbor rule. But it's always been a question in the advisory business. If you give investment advice to all of your clients, and it is the same, no matter who the clients are, have you inadvertently created an investment company? That has been termed the MiniAccount Problem, but the bottom line is it remained a question up until a rule was adopted under the Advisors Act, Rule 3A4, that is a safe harbor. And as I'm sure all of you know, you can't violate a safe harbor. You're just either in it.
Investment Company Act.
Under the Investment Company Act, correct. You're either in the safe harbor, so you have its protections, or you got to hunt around and figure something else out to defend yourself. Under Rule 384 under the Investment Company Act, there are a number of conditions and requirements that you need to meet if you're going to claim that a discretionary advisory service that provides all clients basically the exact same advice is not indirectly the creation of an investment company. And I want to hone in on one of those requirements in particular, which is that the client has to be able to impose reasonable restrictions on the investment of his or her account. Obviously, in the robo-advisor situation, that's a little challenging to do, but we have seen some robo-advisor providers allow clients, as I mentioned earlier, to say, I don't want to invest in, I don't want my account assets to be invested in, and you get to pick 3 funds. Presumably in that case, there are either 3 alternatives that are immediately used to populate that space, or all the other non-suppressed investments are invested in to a greater extent, making up for what the client has suppressed. I think that it is very difficult if these robo-advisors have few investment advisor reps, people to talk to. And so what I have always felt about this 3A4 and this safe harbor is you may be in a situation where, practically speaking, you've got 5 models, that's it. There is no way to, in your program, to allow a client to impose a reasonable restriction or to say, I don't want you to invest in fill in the blank, any funds within this complex. It may be impossible for you to do that. So what? So you don't have the safe harbor to protect you. What can you do? What exists in a robo program that might give you a sufficient legal argument and basis to conclude, so what, everybody's in one of 5 models, I haven't created 5 mutual funds. And the answer is, as opposed to an investor in a mutual fund, a client on a robo platform that does not allow for reasonable restrictions still has legal title to all of his or her fund and ETF holdings in their account. They don't own a security that entitles them to an undivided interest in everything in a pool. That's a distinction between an investment company interest and a non-investment company interest. I, as a client on a robo platform, if I can pledge my account for some other loan or borrowing that I want to engage in, I can do that. I can't do that with the assets of a mutual fund. So you can defend against a claim that you have an inadvertent investment company by identifying those areas in any advisory program with a separately managed account capability, the differentiating factors between what clients own in that program as opposed to a mutual fund. Are we out of time?
No, we are not out of time. I think I was just looking to see if we had some questions here. I think we've had a couple. Here's one about 3A4. How about the requirement in 3A4 to have personnel of the manager who are knowledgeable about the account available for consultation?
I guess, you know, there has to be a human that is sort of at the helm of creating a robo-advisor platform.
Is it enough that a human has developed a Q&A or frequently asked questions, responses, some of these interactive tools that you can use on a website where you see a word that people frequently have questions about, you hover over it with your mouse cursor, and up comes some, description or additional information.
Never had to use that as a defense against the dark side, but I would certainly try. It is sort of modernizing that requirement in the safe harbor. And again, I can't emphasize enough, it's just a safe harbor. It doesn't mean, if that was the only thing you were missing, I don't want to talk to anybody, I don't want to have to answer anybody's questions, I don't want to consult with these people, you take it or leave it, I'm not providing anybody. I wouldn't say that per se means that your platform has automatically transmogrified itself into an investment company.
For all the other reasons.
Right, and that, it seems to me that that is a very good way of meeting this element to the safe harbor. Why not?
Right. I don't think we have any other questions. Are there any additional things you wanted to mention, Stephanie, before we wrap up here? I think we certainly talked about, a robust model management compliance program is going to be very, very key here to avoid regulatory risk. And your disclosure and the way that you communicate with your clients through the platform on the internet is going to be key to what kind of exposure you might have.
And the client contract.
And the client contract.
Right. If you are going to reduce your risk and your liability for errors, for example, and everybody should, because inevitably errors in models seem to happen. But if you're going to try to reduce your liability by contract, you want to do it in a very, very plain English way, and you want to be sure to include in there the standard, which is, the federal and state securities laws impose liabilities even on people who act in good faith, and no reduction or attempt to reduce our liability is intended to signify a waiver of those rights to the extent they exist. But I would try that, although most advisors pony up when the mistake is clearly theirs. So I haven't been in a situation with a gross negligence exculpation provision and an advisor resistant to cough up damages or put money back into accounts when the error was obviously theirs.
So one other question came in. How concerned do we think the SEC staff is about 3A4 and Investment Company Act status? It was basically a footnote in the guidance update. I don't know what to read about that. Is that they are raising a little flag, but they weren't comfortable writing about it? I mean, what is that?
I think that I read that part of the guidance statement as being sort of a warning, honestly. I think that bringing inadvertent investment company cases is very, very difficult for the SEC staff. They don't have a great track record. I think the last time they tried to do that was National Presto, the company that does slicing, dicing, and mangling your fingers with slicers so that you can make a great, meal. They ended up losing in court. So, but they were bringing a case claiming that it was inadvertently an investment company. I have always felt, but this is my own personal view, that 3A4 really was unnecessary because I think that the differences in the ownership of a separately managed account versus a mutual fund share is gigantic. And even when I was on the staff, I would have loved somebody to have challenged this mini-account theory that is embedded in this 3A4 rule. so do I think you need to worry about it? No, but in designing these programs, having some computerized way of connecting up with the clients once a year, if you do allow, say, something like suppression of 3 different funds, remind the client by computer once a year, oh, by the way, here's a reminder, you can suppress the investment of 3 funds. This has been your choice in the past, you haven't done it, but we're reminding you you can. I mean, there are little bits and pieces of this rule that you could weave into the program, and it would give you a little bit of protection, but
and maybe this is just something that was picked up by OC as it goes out and examines those robo-advisors who might be dipping their toes in the investment advisor regulatory world for the first time, that maybe they didn't have 3A4 and Investment Company Act status on their radar?
Well, I mean, you have to admit, even from the SEC's perspective, there's something on its face that seems to clash, providing a discretionary service. Give me your money and I'm going to manage it for you. And there's no human interaction. That just seems to be an inconsistency in concepts. And so that, of course, would capture the staff's attention in those circumstances.
Right. Well, I think that we are close to being out of time here today. And so I think that wraps up our program. And on behalf of Mayor Brown and Stephanie, thank you so much for your time. I hope you found the program useful. There are some final housekeeping items for today's participants. A recording and a link to the materials from this program will be distributed by email in the next day or two. And for those applying for CLE credit, please note that the certificates of attendance will be distributed within 30 days of the program date.
Aim, do we just want to say for those of you, well, you're hanging up, so we do have our Investment Management University coming up in May. And for those of you who are interested, I'm sure you could write in, but these are programs we've done for 11 or 12 years now, one in New York and one in Chicago, where we talk about investment management issues the whole day. So if anybody is interested in that, of course, regulators and press are not invited. So other than that, anybody interested, communicate with us. We'll be happy to give you that information.
Absolutely. And thank you very much, everyone. And now I'll turn the call back over to the operator for the closing formalities.